Compelling talk you can count on. This is the Mildred Gaddis Show on News Talk AM 1200 and 99.9 FM WCHB.
Last week's surprise decision by a local judge to drop the most serious charge in the Aiyana Jones shooting is going to stand, but the court making that ruling today did so with reservation. Steve Gerald is here to take a closer look. Steve?
Well, Devin, it's actually a little bit confusing because the Court of Appeals offered some mixed opinion today on whether Wayne County Judge Hathaway made a mistake in dismissing felony charges against Officer Joseph Weekley. But the appeals court panel was unanimous in its decision that it will not consider the question. So the ruling stands. The legal argument on Friday was over the word willful. Weekley's attorney argued that a conviction of involuntary manslaughter required that Weekley knowingly created danger and intended to cause injury, and that no proof had been offered to show that. Wayne County Judge Cynthia Gray Hathaway agreed and dismissed the felony charge of involuntary manslaughter. Prosecutors filed an emergency appeal. Today, the Michigan Court of Appeals says it is barred from reviewing the trial court's decision. Appeals Court Judge Michael Talbot commented today he believes that Judge Hathaway erred in granting the motion for dismissal of the charge, but says the Court of Appeals is barred from reviewing the decision. So that ruling to dismiss the felony charge of involuntary manslaughter will stand.
It's a major victory because now he's just facing a 2-year misdemeanor that goes in front of the jury, and it's going to be the question of whether or not there was a reckless discharge of his gun.
Roland Lawrence, chairman of Justice for Aiyana Jones Committee, says the group is pushing for a review of the decision by the Michigan Supreme Court. So with that, I guess there is no clear-cut answer. Wayne County Prosecutor's Office has asked the Court of Appeals to reconsider, but that's not likely to happen. Trial is expected to resume tomorrow with closing arguments.
Welcome back to the Mildred Gaddis Show. My guest has been honored as one of the best lawyers in America. Attorney Gerald Thurswell is a highly regarded expert in medical malpractice, birth injury, as well as auto accident litigation. He's been recognized, as said earlier, as a super lawyer by Law and Politics magazine, a listing of the top 5% of attorneys in Michigan. He is the founder of the Thurswell Law Firm here in metropolitan Detroit. He is my guest. Good evening, counselor.
Good evening.
How are you doing?
I'm doing fine. Happy birthday.
It's coming up. It's coming up. Thank you. Let me ask you, what's the difference here? Because the jury is out, I understand, on this misdemeanor charge. Help us understand what happened on Friday and what the difference is.
I think I can describe to you what happened on Friday, although I have real problems with agreeing with the judge's decision. She found that there was insufficient evidence that the elements of the crime were not met, and therefore, because the elements were not met, that the jury could not consider whether or not Weekley was guilty of involuntary manslaughter. There are certain elements that have to be presented, that he created a danger, that he willfully then discharged his gun. She stated that there was insufficient evidence on those elements. Then she entered an order, discharging him, acquitting him, letting him off. Once that order was entered, then the prosecutor appealed to the Court of Appeals, and the Court of Appeals denied the appeal and said that her decision has to stand. That's very, very similar to a jury going out. They deliberate the case, they go out, they make a decision, and they find somebody not guilty. You cannot then go back and retry them a second time. That's double jeopardy. Once she has signed that order, dismissing the charges against him, after the jury had heard all the evidence, you can't retry him again. Judge Talbot from the Court of Appeals said he had disagreed with both the substance and the form of her order. Many times people disagree with the jury decision, that if somebody's acquitted, they're acquitted and you can't try them again. And Judge Talbot had to sustain her dismissal of the charges. So I don't see how this case can be appealed to the Supreme Court or anywhere. I think this is the final decision, and Weekley is going to be a free man on the involuntary manslaughter charge.
In the maximum sentence on the involuntary manslaughter is what, 24 months?
Yes, that's correct, 2 years.
Now, can a judge, let's just say the jury says yes, he's guilty on this misdemeanor. Can a judge decide, although the max is 24 months, that he doesn't have to go to prison at all, or go less than 24?
Yes, she can just give him probation. She can give him a fine. He doesn't have to serve 1 day in jail. You know, a very interesting thing occurred in this case. Very interesting. She was the same judge during the first trial when Weekley, was charged. Went through a whole trial, and she let it go to the jury the first time. I have to presume that the evidence during the first trial was the same or similar to the evidence that she just heard. So why did she let it go to the jury the first time? If you'll recall, the decision in the first trial was there was a hung jury. The jurors couldn't decide guilt or innocence, so they had to have a new trial. Very interesting that she didn't do it that time, and now she's doing it this time.
I'll say that again for us.
Okay.
Take my hand and walk slowly with me so that I can understand this.
There's a trial. Weekley's on trial, and there's a hung jury. 12 jurors go out to decide his fate, and the jurors can't come to a decision. It's a hung jury. So they dismiss the jury, and then they're going to have a retrial. And the retrial is the trial that just occurred now. And I have to presume that the evidence presented during the first trial is the same or very similar to that which was presented now. Why didn't she throw the case out during the first trial? Why didn't she let it go to the jury then? So I said to you, why didn't she let it go to the jury now? Why didn't she let the jury, after hearing all the evidence, let the jury decide whether or not the elements to prove guilt were met? She believed this time that some of the elements were not met. And she didn't want the jury to speculate and come up with a guilty verdict when there was no evidence on some of the elements in her opinion. So she took it away from the jury.
That is interesting. Quite interesting. 568-1200 is our number here on the Mildred Gaddis Show. Attorney Gerald Thurswell of the Thurswell Law Firm, my guest. We're talking about the case that's traveling through one of the courtrooms here in Detroit, having to do with the Detroit police officer who shot and killed 7-year-old Aiyana Jones in a police raid. Some interesting twists and turns regarding this case. Stay with us. 568-1200 is our number. If you have a question or comment, we'd like to hear from you. It's 5:35 in the Motor City. Attorney Gerald Thurswell, my guest here on the Mildred Gaddis Show, and we're talking about what's happening in court concerning the Detroit police officer Weekley, who's charged in the killing of Aiyana Jones. You probably know by now that that case has been diminished to a misdemeanor case. Judge Cynthia Hathaway is the presiding judge in this case. Ron, in Detroit, you're on the air with Attorney Gerald Thurswell. What's your question or comment, please?
Thank you for taking my call. I wanted to get some clarity on the comment that he made, and I just want to make sure I understand correctly. You were saying that because the judge dismissed the manslaughter charges and entered the order of dismissal, that he could not be retried because that would constitute double jeopardy. Is that correct?
That's correct.
Okay, so with that said, how is that any different than in cases where, for example, an essential witness to the prosecution doesn't show up? Let's say a police officer didn't show up to court and the judge dismisses the case, and the prosecutor rewrites it later on and brings the accused back before a jury. How is that any different?
That's a very, very good question. What happened in this particular case is that the prosecution presented their entire case. And then the prosecution then said, I rest, telling the judge, this is my entire case. This is it. And then the judge has to make a decision whether or not there's sufficient evidence to let the jury hear the case.
Got it.
In the other situation, somebody is charged and there has not been a trial where the prosecution has put in their entire case, where just the witness doesn't show. What has to happen for double jeopardy to get involved is the prosecution has to put in their whole case and then say they rest. They have no more evidence. In these other cases where they don't put in their whole case, it gets dismissed like you appear for trial and a witness doesn't show and they just dismiss. Well, the person hasn't had a trial. So that's the distinction.
I appreciate that. Thank you.
Sure. It was a good question.
Ron, thanks for checking in. Leroy, what's your question or comment for Attorney Gerald Thurswell?
Yes, I'd like to know, why wasn't the grandmother charged with child endangerment? If she's holding the criminals in her home, it seems to me that she would know that the police got to show up some kind of way. And I want to know why isn't she charged? And I'll hang up and listen.
That's interesting. She's not going to be charged. She's not going to be charged. It's just, I hear what you're saying. It's like taking your child to I don't know, let your child play in the middle of the street. Play with your child in the middle of the street, gets hit by a car. She set the child up for harm. I understand exactly what you're saying. Very, very sad. Isn't it so sad?
Attorney Thurswell, as you look at this case, as people look at this case, some may find it confusing, and here's what I mean by that. Anytime police kick down a door and enter a dwelling, they don't know what they're going to come in contact with. They think they know. And it's unfortunate, and I tell you what I'm troubled by. I'm troubled by the fact that the police, in its ability to conduct surveillance, did not know that individual was not in that home. I don't understand that. It seems to me that you would be out there, and if it takes you 48 hours to see him come and go, you wait those 48 hours. Just don't go in at any time thinking that you're going to get him. I don't know what their process is. Or what happened in the midst of all of this. But people are confused by the fact that the police didn't have it right, that the person was not there at that particular time, although he had been staying there, but he was not there at that time. And some may be confused by the fact that the officers really didn't know what they were going to run into. And they don't know whether or not this grandmother grabbed the man's gun, or he got nervous, or whatever. And if you ask people, I think if you conduct a poll, do you think this guy intentionally killed this girl? I think most folks will say no.
Don't you think they had surveillance of the house? And don't you think that they knew that the grandmother was in the house with a baby, with a child? And when you go into the house with guns, these are not pistols, these are rifles. These are automatic rifles. You go into the house with automatic rifles, you do that flash where the light goes up, and you know there's a grandmother in there, you know there's a baby, because they had to do some surveillance.
Yes. And then you know what I missed?
You're very carefully. You have a baby that you could have. Why don't you wait for him to come outside?
You know what?
What was the rush?
48 hours. A&E.
Yeah. That's correct.
A&E. And it's most unfortunate. But that seems as what it was. It's waiting on the network to get there to film it so that they could make that 48-hour segment. And a 7-year-old child is deceased as a result here.
Innocent little baby. An innocent baby. For no reason. No reason. There was no reason. I don't think they even had to go into the house. Why did they wait for him to come outside? I don't understand that. I don't understand it.
So let's just look at worst case scenario. Worst case scenario, this jury comes back and says that Weekley is not guilty of anything, not even the misdemeanor. Game over? Criminally?
Because there's a civil suit against the police officer in the police department.
Other than the civil side, but criminally, no more. That's it.
There's no accountability through the criminal justice system. He is walking, he'll get away with it, and there's no accountability in the criminal justice system. Hopefully the family will receive some monetary compensation, but I don't think that that's sufficient. When people get killed in situations like this, That's why we have two systems, both the criminal justice system and the civil justice system. People have to be accountable for their acts. I'm not saying that this officer intentionally went to hurt this child. I don't know what happened in there. But I do know that he had an automatic rifle. The police department decided to flash it. As you correctly stated, filming this for TV, they had to get in there to make the show. And everybody's a superstar, and I think things got out of hand. And this little girl just started her life 7 years old is dead. Horrible.
Gone. What are the lessons for us to learn from this situation, Attorney Gerald Thurswell?
I think the police department has to be more responsible. I don't think anybody ever intended to hurt this girl, but there's procedures and there's policies, and you just have to follow your procedures, your policies, your training, and you can't get involved in doing a police raid with automatic rifles and a flash. You don't do that for a TV show. You're police officers, you're trying to catch a criminal, you do your job, and you don't try to be a showman. It's just so sad.
For those of you listening to this interview and thinking that the Thurswell name sounds a bit familiar to you, it should, because the Thurswell law firm, Attorney Gerald Thurswell, represents the families of Mackenzie Cochran. He was a young man who was killed in Northland, the unarmed man killed by security guards in Northland Mall. And he also represents the family of Renisha McBride, the young lady who was killed on the porch in Dearborn by a man who has been convicted and sent to prison in that case. Let me give you the number to the Thurswell law firm, just in case you need it. It's 866, let me do it the old-fashioned way, 1-866-354-5544. That's 1-866-354-5544. Attorney Thurswell, thank you so much for joining us. We'll see what this jury comes back with.
Thank you. Have a good night.
Okay, you too. Bye-bye.
Thank you. Bye-bye.